requesting a dissolution of the marriage from her husband. Those grounds can be best summarized as having irreconcilable differences with her spouse. Now we get into the issue, gee, what are irreconcilable differences? Well, actually, an irreconcilable difference is any difference which the spouse enunciates or which the spouse speaks to the judge and says that for this reason she wants the marriage ended. From a practical standpoint, we have seen a range of irreconcilable differences enunciated as, he beats me on a regular recurring basis and I fear for my life, all the way down to, Judge, she don't feed my hunting dog right. So whatever the irreconcilable differences are, the court will, as a matter of course, allow the marriage to become dissolved. We have occasionally, in the practice of law, one spouse wanting a dissolution of marriage and the other spouse fighting it or not wanting the dissolution of marriage. It is not uncommon in the private practice of law for a woman to come into your office and state that her husband has filed a dissolution of marriage petition against her. And she'll further go on to state that, gee, she really doesn't want this dissolution to occur because she still loves her husband and thinks that the marriage can be saved. Well, from a practical standpoint, it is a very sad circumstance. But what is a lawyer to do under the law in that particular case? Well, what a lawyer can do is to petition the court for a reconciliation or a conciliation conference. And they do this by requesting in writing of the court to require the parties to undergo a, quote, conciliation conference. The circuit court judge, as trial judge in these cases, can then decide whether or not to award a conciliation conference. If there are reasonable grounds that are spoken by one party or the other, he will usually request that the parties undergo a conciliation conference. And those are usually held by some sort of marriage counselor or someone qualified to counsel people. The parties then are required to report back to the court as to either the success or failure of the conciliation conference. If the conciliation conference fails and the party who requested the dissolution of marriage requests the court to go forward, the court, as a matter of course, will go ahead and proceed with the dissolution of marriage. So even though someone wants a conciliation conference and the court awards that conciliation conference, if the other party doesn't want it or if the conciliation conference goes poorly, there are no grounds to tie up or stop or terminate or in any way slow down the process of the dissolution being granted. The court will then set aside the conciliation conference idea and go forward. When can a fault become an issue? Kentucky is a, quote, no-fault state. So no matter who was at fault, be it the husband or the wife, fault will not be considered in a dissolution of marriage as to whether it should be granted or whether it should not be granted. Courts no longer assess fault against one party or the other, as I have earlier indicated. However, there is one isolated instance in which a court can consider fault, and the area where it can consider the fault is in the area of maintenance. Maintenance is another word used for alimony, that is spousal support. Both maintenance and alimony mean support to the spouse as opposed to child support for the children. getting back to the issue, when can fault be considered? In the area of maintenance, once a judge decides that maintenance should be awarded to a spouse for whatever reasons, then a court can consider the issue of fault. This principle was decided by the Chapman case